Monday.
Wednesday. Wednesday might not be.
Monday. I will argue it now.
Item 30.
Lordship, in the previous matter at 20, Lordship has granted to approach him.
Yeah.
Yes.
Wait, please,
Shoaib, you are ready with the matter now because since he was appearing in person, we thought we'll have some assistance.
That's right. Yes. So, Mulot, the first hurdle that I'm facing today is a 165-day delay.
Okay.
So, Mulot, insofar as the delay is concerned, he has filed certain additional documents, and there are also 2 grounds in the delay continuation application. He says, Mulot, that is, if your lordships may have the delay continuation application.
What's the ground for delay?
The ground is, Mulot, his father had passed away, old ailing father, and there is medical record with respect to that. He had bed sores. He was the one who was looking after him. Then he has certain other medical
merits. What do you have?
On merits. Now, Mulot, on merits, striking case where for 24 years he's been embroiled in proceedings. The arbitration started 24 years back. And Mulot, at the end of it, there are 2 claims which the High Court in a 37 petition identifies and says that you're actually entitled to this, but my hands are tied because the scope of a 37 Mulot, as the High Court rightly said.
The High Court, after holding on his favor on merits, why does the High Court say that its hands are tied?
Mulot, because of the scope of a 37. So that is how Mulot.
Now, his claim is basically for interest on the entire component of EMD. Even that which is refunded, right?
Correct. That's right.
His claim is that I'm entitled to interest not only on that portion of the EMD which is not refunded,
right,
but on the entirety of it.
That is right. And
that is that clause 4.5.
Right, 5.344. Now
the High Court holds in his favor that is the clause.
You have an entitlement to that.
Why does the High Court delegate him to other?
Because the High Court says that I really cannot modify, and it relies upon the judgments of this honorable court that since the
award cannot be modified.
Or award cannot be modified. So that's where the restriction comes in. So, Mulot, my suggestion in the special circumstances of this matter, and especially Mulot, for 24 years that it's been pending, several other claims have also been allowed, is Mulot, your lordship's exercise of the constitutional power under 142.
How much would be that claim in respect of interest?
So 1.5 lakh rupees is the amount, Mulot. It's about a 6,000 rupee refund on sales tax.
He's been fighting for 24 years for 1.5 lakh.
That's right, Mulot. That's right. Vicinity of that. So,
we'll just close our eyes to the fact that there's a delay of 165 days. We'll issue notice to Steel Authority and we'll try and do some.
I'll be very grateful.
Some justice to your plan. No point in now asking him to invoke arbitration
again and restart again. And in similar situations where there was a similar situation where the High Courts are directed for a reinitiation of the arbitration on some other severed issues, your lordships have exercised 142 and actually condoned and said that we'll grant something here. So I have those judgments.
We've heard Mr. Shoaib Alam, learned amicus curiae. There's a delay of 165 days. Issue notice on the special petition and on the application for condonation. We'll keep it returnable on a particular date. Otherwise, you might.
And thus the service, Mulot, will be the standing counsel. Very deeply impressed. Most yes. Grateful, Mulot.
Item 31 minutes.
Yes.
Whereas in 31, even though the state is not on caveat minutes, but we have been served with an advance copy in this matter. I have a request to make on the behalf of the learned SG minutes. If minutes may keep it on Monday, you will be able to address minutes.
Very well, minutes.
I'm grateful, minutes.
Ryan for the caveat to appear for the caveat, I'd like to appear for the petitioner. That's the statement.
Minutes, before my friend starts, minutes. This matter has been going, that is 31, rolling for 4 or 5 dates. Would your lordships be able to, let's take it up higher?
No, we are taking it on Monday. We would have taken it up the SG.
No, your lordship says right. No, I'm only asking in a position where it will be taken up.
Monday,
high on the board.
No, we take it up on Monday. Let it be done.
Most grateful.
Now, my lord, This is the state's petition. My Lord, I have several objections to the High Court's order, my Lord, in a writ petition. This is a matter, my Lord, concerning supply of electricity. The High Court could not have entertained, my Lord, a 226. The High Court says, my Lord, in the order, there is no absolute bar to 226, which, my Lord, we all know. But if there is a discipline, my Lord, of a special law, then you must maintain that discipline. That's the first thing, my Lord. Your Lordship will find in how the High Court has treated that part of the order.
Yes.
Then I'll come back to the merits, my Lord. Your Lordship will find, kindly, my Lord, first see at page 56. Your Lordship will first find at 56. Paragraph 7. The Electricity Act is an exhaustive code in all matters concerning electricity supply, generation, etc., etc. The High Court is conscious. Then, my Lord, the High Court says that this is not, my Lord, an absolute reason, and that, my Lord, your Lordship will find at page 25 and 26, my Lord. There is an arbitration clause also. To that, my Lord, the High Court says in para 25.
Initially, the CERC had ruled that all agreements, including previous PSAs and PPSs, would be overridden by the 2019 regulation.
No, my Lord, it's like this. I am the state.
Right.
They have set up a plant in my state.
Right.
They use my land and my water. From there, they make electricity. So I have an agreement with them that they will, my Lord, give me 12% power. Free. It's like a joint venture. Free of cost, my Lord, 12% for 12 years. And for the remaining
28 years.
28 years, you give me 18%. That is at a time, my Lord, when there is no PPA. I am not concerned with any PPA. I have a JV.
So what is the effect of the 2019 regulation?
And now what happens is, my Lord, they rely.
2019 regulations cap it at 13%.
But that is, my Lord, between the parties to the PPA.
That is regarding PPA.
Kindly appreciate, my Lord. The PPA is between, my Lord, this party and a third party called PTC.
PTC.
In that, my Lord, this is mentioned. And my agreement says that irrespective of whatever may happen, this is what you have to give. I can't, my Lord, as a state, you enter into a solemn agreement today in 2005. And then say after 20 years, some law has come by which I have a contract with somebody else and that caps is at 12 and therefore you are capped at 12. How can you affect my JV? You go away then.
Those regulations of 2019 have no impact on you.
According to me, no impact. The High Court has wrongly, now my Lord, what the High Court did. When this, my Lord, 13% cap came, they filed a writ petition.
Correct.
Writ petition is completely, my Lord, not maintainable. You have an arbitration clause. They filed a writ. The High Court says that your agreement, which is much prior to, my Lord, this CRC thing, must stand aligned to what, my Lord, the subsequent document is, and therefore your 18% will be scaled out. Like the
was that they had moved the CERC
for fixation of tariff.
For fixation of tariff.
That is between them, my Lord, and their
by its order of 17th of March 22.
Yeah.
CERC says that the free pass to be supplied by respondent number 1 to the state was considered at 13%.
But, my Lord, it can't be to the state because I have a separate agreement of 2006. No. How can I, my Lord?
1999.
Or 99.
But the CERC order specifically contains a stipulation so far as you are concerned.
It does. On that basis, my Lord, and
So what is the remedy available against the CERC
now,
order?
my Lord, there are 2 things. You have a right of appeal. Anybody can do whatever.
So you would have been entitled to file an appeal.
I could have,
Only for 6 months.
but not this. Now see, my Lord, this period is 2019 to 2024.
March
Right.
20.
It is not, my Lord, for forever. This order has come, my Lord, in 22 or 23. They go and file a mandamus, my Lord, in the High Court that since this order of CERC has come, you now, by a mandamus, think with our agreement, them and the state of 99. So the High Court says, I will tinker with your agreement because law overrules the contract. This is law, subordinate legislation, and therefore your cap will be the 30.
Got your point.
Now, my lord, therefore, now, my lord, the state is deprived. If you don't want to give and you want to release, please go away. I tried
Yes.
to JV for 40 years
Yes.
and then will not be stuck by events, will not after 10 years, 20 years to say that you are now in there. And how does the High Court entertain will not at 226? Neither 226 maintainable will not nor arbitration. And now, my lord, plus 5 years is over. 5 years is over.
Correct.
Despite that, for the next 5 years, which will be 24 to 29, they are capping it at 12%.
Yes.
Their obligation is 18 million.
Yes, even today, even today.
Yes, Mr. Chidambaram.
Lord, 2 points. Tariff regulations were made in 2019.
Right.
He is a deemed licensee under Section 14, proviso. Yeah, he is a deemed licensee. Tariff regulations bind all licensees. Tariff regulation of 2019 was not challenged by anyone. Tariff regulations capped it at 13%. Point 1. Point 2. He was a party to the CRC order dated 17/3/22. He did not file an appeal against that order. So both are in my favor. The regulations are in my favor. The regulator's order, adjudication order is in my favor. He did not challenge the regulation. He did not file an appeal. But ignoring the regulation, ignoring the order, he demanded that I supply 18% free power, failing which he will terminate. Therefore, I went to court. Where do I raise a dispute? The regulator has already
He
decided.
was a party to the CRC order.
He was a party to the CRC order. He didn't file an appeal.
What did CRC direct insofar as he was concerned?
CRC said
PPA, please be.
that the 13% is in the tariff regulation and therefore it binds everybody. You cannot give more than 13% free power, and that alone will be taken into account for calculating the annual revenue.
So right or wrong, he was bound by the order of the CRC.
He was bound, he's a deemed licensee. He's bound.
Carried it in appeal to
He
APL.
could have challenged the regulation. He could have challenged the regulation saying this is interfering with my whatever rights state has. He could have filed an appeal against the regulator's order. Where do I raise a dispute? I can only go to court when he threatens me. When he threatens
if
me
you
with
don't comply
termination.
with my...
Yeah.
Two more sentences, Manoj. That order which your lordship will get at 6:15 to 6:17.
It's only.
Well, it's my learned friend, not only a party.
That's an extra 15, right?
Yes, 17/3/22. It starts as 5:38. I'm again sorry, your lordship should be having the PDF. It starts at 5:38. Maybe the PDF is 577. This is very interesting.
Starts at 5.
Yeah,
577.
they are. Government of Himachal Pradesh, Shimla.
That's right. Now, the relevant portions are two, para 144 and 147, which is at page 615.
615.
Internal page, right?
Yes, Manoj, the normal page, not the PDF page. It should be 654 PDF.
Yes, 25.
Otherwise, 615.
Yes.
Now, your lordship will note one thing. What is CRC, Manoj? CRC comes in only on multi-state. Unemployed says he is state. CRC comes in only when there are multi-states. Otherwise, there is no intra-state. There is a regulatory authority. So, he is a state who is a party. He accepts this. He doesn't challenge it. Then, Manoj, when they demand and I go to court, the court does what? The court cites the lordship's PTC judgment in 5 paras. PTC, your lordship, considered the issue in great depth and said in 5 paras quoted in the impugned order that you cannot have the regulations being trumped by any form of circular, contract. Otherwise, why was Electricity Act created?
No, which-
You were having free electricity supplied here and there.
Finding that you are relying upon. Para
Yes, 144, which is page 615.
PTC cited in
615.
146.
Just see 615. How can he be there and not challenge? He's now doing a collateral challenge.
Implementation agreement.
144. We have examined the matter in terms of the implementation agreement. Does the sentence start with? The
Yes.
para is more reliable. We have examined the matter in terms of the implementation agreement dated 18th of November. The petitioner and the government of Himachal directly. Free power equal to 12% of net generation is to be supplied by the petitioner to the government of HP for the first 12 years from COD for the next 20 years after expiry. PPA, supplementary PPA executed by the respondent defines the term free power, which is the same as the aforesaid provision in the IA. It is therefore evident that the issue of free power is significant relevant for the 19 to 24 tariff period. Now come to 147, 2 pages later. 146 and 147. PTC is only 1 para here. In the impugned order of the High Court, it's in 5 paras. Quoted. 146. PTC has laid down the principle whether any provision of the agreement falls in the domain of the regulations or subordinate legislation has to be aligned with the regulations. And your Lordship is being asked to fault the High Court for following the Lordship's judgment. The relevant portion is as follows.
No, read that.
And one must understand why a regulation. Last 5 lines, last 5 lines.
Once you have the CERC order,
It doesn't go to appeal.
possibly we assume for a moment that it's an erroneous order. It's an order which binds you. You had to challenge the order. You never assailed the order in an appeal.
Kindly come to 617,
617.
We are on 617.
Your Lordship, C147.
Yeah.
Thus, the provisions of the PPA. Milord, my agreement with him is called Implementation Agreement of 99. It's not a PPA.
Yes, sir.
Thus, the provisions of the PPA executed by the petitioner JSW with PTC in respect of free power to the home state is wrong. Free power to the home state comes Milord, from an implementation agreement, which your Lordship will see now. Just kindly have a look at that. That
144 talks of implementation.
it may be a party, but this, Milord, with respect, how can this come in my, sorry.
144 talks of implementation agreement. First line of 144.
Electricity Board. We were, but
In terms of the implementation,
Objection I have.
1 minute.
There is an arbitration clause.
Implementation
There
agreement
is an
is mentioned in
arbitration
the first
clause.
line.
How can you file a 226?
Implementation
There is
agreement.
an act here.
144.
yes.
Milord, suppose, Milord, I would terminate. Let's, Milord, my Lord the Chief Justice said, you are a party. I will terminate your agreement. Can you file?
He is wanting money.
Arbitration, your Lordship have said,
regulate.
is by and large an absolute rule of arbitration. Can't do this.
Contrary to the regulation
demand-
and contrary
You are
to the
dodging your
legislator's order,
responsibility
he
to
makes
the
an
state of
illegal
Himachal
demand
Pradesh.
upon me. The illegal demand can only be challenged under Article 226.
Sorry.
The arbitrator is the
you are-
regulator.
But arbitration
Why can't he go in the appeal to
How
APTEL?
can it require?
Why can't he go and appeal to APTEL?
Suppose, Milord,
CERC.
suppose, Milord, yeah.
Why did not
Milord,
challenge the order?
I can't say, Milord, for some reason they didn't challenge. Or
accept
you know that this. I didn't challenge. I am bound by it. Therefore, Milord, there will be a mechanism to execute the order. That mechanism will have to be, Milord, in the act. The mechanism will be in arbitration.
Yes.
The mechanism of execution can't be in 226. Then I will align. How can you align? If you have, Milord, a decree, you execute it. You don't find a 226 to execute a decree.
Basically,
Therefore, the first question is, Milord, is the chicken and egg story. First question is, could you have gone to the High Court?
yes.
In the presence of a self-contained code, number one. And number two,
Arbitration clause.
the arbitration clause. How can it be, Milord?
Issue notice.
Well, if a government authority,
Says you can align, must align. PTC says.
Then not will issue notice.
Cannot be aligned.
no, please allow me 1 minute. If a government authority makes a demand upon me contrary to a statute, Should I not go to Article 226?
No, you will go to arbitration.
This is a government authority, contrary to a
What we do,
statute.
we'll render judgment. on this.
Decide, Lord, it's a
Not a matter
huge
where
matter for the
there's
state.
absolutely no state.
But the Lordship will be very clear. Next steps, question sentence will be give me interim relief.
No.
Your Lordship should not bother at all. I'm
Actually
objecting.
something.
I'm objecting.
But after the order, they are giving you only 12% against 18.
Long time.
1 second, please. I am saying, give me 18. I am the state. If I lose, we will adjust. Not for the next 20 years.
Long time is getting 12.
The state is leading in economic problems. We've had flood festival. We've had. You are a big company. Why should you not give me 18? Subject to Lordship.
It's a 28-year contract we can make up later on if we lose.
If I was to lose,
20.
there is 28 years of adjustment.
Explain the mechanism.
Yes.
There's a mechanism to making up.
Please,
We lie in favor of Lord State and its people.
Alternately, today, the difference between 12 and 18, suppose you requisition 18%, up to 18%, you will have to pay.
Yes.
Otherwise, you'll have to pay.
no, he doesn't. It's free power, my lord, for him.
This is all problem of free power.
My lord is saying.
He doesn't
if I
pay.
get 12, but I want 18. That's what
It will be adjusted. Malad. It will be adjusted.
No.
But there is one more.
Please see this, my lord. Free power, the total power minus free power is the saleable power. If I give him 18, because the regulator's order says you can only give him 13, my saleable power will be calculated at 87%. The division bench has gone into it, 87%, whereas I'll actually be able to sell only 82%. The 5%, I won't get any money.
Cascading effect of the entire tariff.
We adjust.
The entire tariff.
Selling even to.
Let's see one more thing.
No, Lord. The order is in my favor.
Yes.
Not
Can't come
High
across
Court
the
is in my favor.
They have succeeded before. Yeah.
One more.
Yes.
This was a period of 2019 to
24, March 24.
The band is 24. Now there will be a separate band for 24 to 29.
Right now, my fixation agreement comes
So
again.
at the moment, there is no fresh fixation for 24 to 29.
Will
It
be
happened
done.
in 5 years.
Same principle of CRC.
If there is no fixation today, then my implementation agreement of 18 will survive.
No, my lord. Until the new regulations are.
You will hear it out, but the Lordship will hear it.
Not here, since they have succeeded, it would be unfair to now.
Lordship, please.
put them down.
Lordship.
There's a division bench judgment. We'll simply issue notice.
Lordship.
We'll give you 3
Certainly.
weeks time to file a counter.
Lordship.
Here and dispose it.
I have a very short issue.
Can you file a counter in 2 weeks?
Yes, certainly. Certainly.
End of September, bloody also may give it.
September, we'll keep it. filed.
Certainly.
Short.
Certainly.
Grateful.
Obliged.
33. Wait, please, Your Lordship. Now, this is the matter where Malad, Wazir X, which is the largest cryptocurrency exchange in India,